Hello viewers, welcome to my YouTube channel. In my previous video, I have presented a Rajasthan High Court order in which a candidate who had failed in the plus 2 examination in chemistry was allowed to take part in the counseling and admitted in first BDS degree course. He continued the course for a period of 1 year, and thereafter it was noticed by the university authorities while registration about his ineligibility to admit into the course. Therefore, his admission was rejected. He approached the court, and the court finally passed orders of compensation of 10 lakhs each to the candidate, both by the counseling authority and the admitted dental college. Now, today I am going to present another case. All the cases are pertaining to medical admission challenges. In this case, a candidate admitted abroad in MBBS without getting the eligibility certificate from Medical Council of India, and also give a misrepresentation of his age in the application. The Medical Council of India rejected the request, but however, the High Court of Manipur allowed the petition. Otherwise, the candidate face hardship if the eligibility certificate was not issued. Let me go into the history of the case. A candidate passed his matriculation exam in the year 2012. He passed his higher secondary examination in 2014. He applied for an undergraduate medical course abroad in Ukraine. After getting admission and joining the course, he filed an application on 2019 for issuance of eligibility certificate, in which it was stated that he was 17 years, 3 months and 30 days on 31st December of the admission year. The date of birth given in the application form filed for issuance of eligibility certificate was 1/11/1998. A show cause notice was issued by the MCI in 10/2019, directing the respondent's son to explain as to why his application should not be rejected on the ground that he had pursued admission to MBBS course before he attained the age of 17. An explanation was submitted by the respondent to the said show cause notice. However, since no order was passed by the MCI, the candidate approached the court for a direction. The court also directed the MCI to dispose the petition within a period of 1 month. After that, the Medical Council of India in 2020 rejected the grant of eligibility certificate on the ground that he did not attain the age of 17 years at the time of admission in 2014. As per Class 4.1 of Graduate Medical Education Regulations 1997, a candidate seeking admission in MBBS or equivalent medical course shall complete the age of 17 years on or before 31st December of the year of admission. However, the court allowed the writ petition on the ground that the candidate would face hardship if the eligibility certificate was not issued. The rejection of the application by the Medical Council of India is on 2 counts. 1. He had not attained the age of 17 at the time of taking admission. Another, he has not obtained the prior permission and eligibility certificate from the Medical Council of India before proceeding to abroad to take up the MBBS course. However, the Manipur High Court allowed the petition, otherwise the candidate would face hardship if EC was not issued. Aggrieved by the decision of the Honorable High Court, the NMC went on appeal before the Supreme Court of India. The Supreme Court, after hearing the case, finally passed order. I will read out the operative portion of the order. The practice adopted by the respondent in getting his son admitted in the medical course in a foreign university without an eligibility certificate is deprecated. Further, furnishing false information to the authorities for the purpose of issuance of EC is an attempt to hoodwink the authorities. In view of the admission of the respondent's son being contrary to the regulation, and in view of the false information given by the respondent in the application filed for EC, in the normal course, we would have set aside the judgment of the High Court and allowed the appeal filed by the NMC. However, in the peculiar facts and circumstances of this case, taking into account the future of respondent's son, who has completed his medical course in June 20, and that he was not responsible for whatever was done by the respondent, we are not inclined to interfere with the order passed by the High Court. The appeals are accordingly disposed of, pending applications, if any, shall stand disposed of. The respondent is directed to pay Rs 10 lakhs cost to the Manipur Legal Services Authority within a period of 8 weeks for filing a false declaration in the application form that was submitted for issuance of EC. Subject to the above, the appellant is directed to issue the eligibility certificate within a period of 8 weeks. In addition to the payment of cost, the respondent's son shall perform charitable service by working with the government for a period of 2 years after his successful completion of FMG screening test. The contempt petition filed by the respondent stands disclosed. This order shall not be treated as a precedent, as it is passed in the peculiar facts and circumstances of this case.